Hi, I'm Jen Benepe, and this is The Real Deal. Behind me is Fifth Avenue, home to some of the wealthiest people in America. And in some of the apartments of the rich and famous in New York City is now unfolding new drama as they too are being pinched by the recession. To wit, The Real Deal has learned that some New York City co-op owners are asking their co-op boards for deferment of their maintenance payment. Those co-op boards, in turn, are also feeling a squeeze, and they are putting off non-essential expenditures. Today, we'll talk to two real estate lawyers about how co-op boards are coping with the recession. Many Manhattanites with high-profile addresses have seen their stock portfolio shrivel or their life savings disappear at the hands of alleged Ponzi scammer Bernie Madoff. Now that pain is trickling down to their building boards, which in some cases are dealing with residents looking to defer their monthly maintenance payments.
Lots of upstanding people have suddenly had the rug pulled out from under them by the Madoff situation and other situations. And obviously that's going to present a threat to a number of co-ops.
The goal in seeking to get a deferment of the maintenance obligation is not to make it up later. It's to have enough time to sell an asset.
Between the declining Dow and job losses that continue to pile up in the financial industry, Eva Talel, who acts as legal counsel to a number of building boards, said there could be many more owners looking for deferrals, and that, of course, could put more co-op and condo boards in a tight position.
If X number of shareholders aren't paying their maintenance, either the other shareholders have to pick up a greater share, or the building has to go into its reserve funds, or borrow money.
Talel noted that New York City boards will ultimately get paid because they have in this state what is called the first lien of repayment. But that doesn't help the building pay for essential building services or for repairs.
The problem is a cash flow problem. How are we going to pay for the fuel, pay the workers, the employees, the real estate taxes, the mortgage, etc., if we've got too many shareholders not bearing their fair share?
Luxemburg, who in addition to heading the real estate department at his firm, is also president of the Council of New York Cooperatives and Condominiums, and he said some buildings may not be able to bear the brunt of deferred maintenance if it comes to that.
Already we have seen reports of maintenance increasing 3% to 15% in the last year and putting a strain on shareholders to begin with, and now this double whammy of the financial markets, a lot of buildings are going to be strained for cash.
Boards are also beginning to forego improvements unless they are essential, and they might also start loosening their subletting guidelines so that owners can continue to pay the maintenance.
We've already seen some indications of subletting requirements being relaxed, and I would expect to see more of that.
There is consideration being given in buildings to defer those non-essential capital projects. Essential capital projects must go on. There are local laws that require certain of them to go on that have to do with maintaining the condition of a facade so that there's no accident and a brick doesn't fall off a building or a piece of stucco and hit somebody and hurt somebody in the sidewalk below. Those kinds of projects, as a legal matter, must continue.
Luxemburg said that one thing boards have going for them is how strict they are about evaluating a buyer's financial stability to begin with. But he said if things get dire, they do have recourse.
To the extent that the board simply can't afford to be compassionate to individuals, the boards are going to be forced to, evict people and force sales of the apartment. And hopefully the apartments will maintain sufficient value to enable the boards to carry on.
Talel, who is also chair of the City Bar Association Committee on Co-op and Condo Law, said that if an owner can't raise enough money to pay their maintenance, there are other legal remedies a board can take before starting default proceedings.
Basically, a legally binding document by which a shareholder basically admits, yes, I am in default. I am not paying my maintenance, and you may treat me as someone who is in default, meaning the procedures that are laid out in the proprietary lease that would otherwise have to be gone through with 30-day notices, 60-day notices, 90-day notices, they're all waived, and the shareholder admits to being in default.
The lawyers we talked to agreed that this is probably not the end of shareholders asking for maintenance deferments. But the question is, will the worst come to pass? Will there be any co-ops defaulting in the near future?
I certainly hope not. That hasn't happened in a long time. But on the other hand, the downturn now is as bad as any we've seen in a long time, so anything is possible.
If a building does default, Luxemburg summed it up in 2 words.
It's ugly.
It all adds up to this. The longer the downturn, the more likely we are to see co-op and condo boards suffering financially. And whether that means someone's deferring their maintenance payment or the board itself can't afford that new lobby, we're sure to see some boards suffering financially over the next foreseeable future. I'm Jen Benepe, and we'll see you next week.